Our next case is due is Nottingham Estates Homeowners Association Incorporated. Are you folks ready to proceed at this point in time?
Yes, Your Honor.
Yes, Your Honor. Each party will have 15 minutes to present their argument. Counsel, you may reserve up to 5 minutes for rebuttal. Do you know how long you'd like to reserve?
Yes, Your Honor, I'd like to reserve 5 minutes.
Okay, very good. I'll be keeping track up here. You'll be able to see it up there. So if you would, just look at that top circle, and that's telling you count down to 5. When you get to 5, that's in your rebuttal time. I'll try to let you about a minute before that.
Okay.
And counsel, I'll try to do the same for you, about a minute left of your time. You're in that middle circle. I'll try to let you know that you have a minute left of your time or so when you get there.
Thank you, Your Honor.
You're welcome. The arguments are being recorded, so when you come to the podium, please make sure you introduce yourself first. Because we're visually and audio recording, please stay behind the podium so we can see you the whole time and hear you the whole time, so that your recording can be clean and we can post it on the internet. I don't think we have any minor child victims in this case. If we did, please use initials or some other term rather than the name of a minor child or victim. I don't think it applies here. With that, we've read your briefs and are ready to proceed on that.
Morning, Your Honors, Counsel, may it please the Court. My name is Brian Smith on behalf of the appellants Shirong and Shasha Tang. I'd like to reserve 5 minutes for rebuttal. Your Honors, there were 2 assignments of error that were raised in this case. They're somewhat tied together. I'd like to address the first assignment of error first, which was, this was a case involving a magistrate's decision. There were objections that were raised. The trial court erred in overruling the objections and adopting the magistrate's decision because there was no easement created for the hike and bike trail in sublot 15 for Applebee's Nottingham Estates HOA. The alleged easement rather, did not meet any of the criteria for an easement. There was no express easement created under either plats 55132143 or 55315277. And that's because, in large part due to the language that says that the trail was to be privately owned and maintained by the HOA. It references ownership and not an easement. And that's an important distinction to make. It's distinguishable from any of the other alleged easements granting, or easement granting statements such as, that contain language such as may enter or may enter to perform maintenance versus saying that it's privately owned and maintained. And the language even references the wrong entity. It was intended as a connectivity, it was originally intended as a connectivity trail. There needed to be a grant to the city or to the public, to the city of Hudson, not to the HOA. And Ms. DeNovi's grant could not carry over after DeNovi no longer had ownership. So now there was also no implied easement in this case because you have to have severance of unity of ownership. The use has to be so long continued and so obvious or manifest to show an intent that it was intended to be permanent. It has to be reasonably necessary to the beneficial enjoyment of the property, and it has to be continuous. The alleged easement in this case does not meet those criteria. There was no need for anyone to traverse this particular private property, this sublot 15, in order to access the either the county bike and hike trail or to access another property. There must be a strict necessity, as the court has set forth in Tiller versus Hinton, and that did not take place.
Do you think, though, that the language, even though it says own versus use, puts an owner, person buying that property, that there is something going on in that part of the property?
Not in this particular case, Your Honor, and that actually brings us to the issue of notice. There was no either actual or constructive notice of this alleged easement.
Constructive notice would be that it would be in the chain of title, right? That's what constructive notice means.
Oh, I'm sorry. Yes. Well, that could be a way of displaying constructive notice, but that in and of itself may not necessarily be enough. And constructive notice in this, there was no actual or constructive notice because what was in the chain of title was only this note 2. And that's also an important distinction to make here. The only even reference to some form of hike and bike trail was this note 2 that was included in one of the documents. It's the hike and bike trail itself is not shown in either plat, only in an unrecorded schematic document. And it's also not a public area. It's a non-vehicular connectivity path, and there's no sublot that abuts that requires either ingress or egress via this path.
That is my question, and I don't think it was answered in your explanation. This language about sublots 1 through 7 will be privately owned and maintained by the homeowners association. In the chain, there's no dispute that that language is in the chain of title. Where is that language located?
That was in, I believe it was note 2.
Note 2 of what?
That was on,
deed?
I believe it was note 2 of the, yeah, I believe it was in note 2 on one of the schematic, I believe it was one of the schematic documents.
So there's a picture associated with the deed, and it has a note?
Yes,
I don't
well,
understand where this located.
yeah, I believe the note 2 was in the, that may have been in the plat document. I'd have to double check that, but regardless, the note 2 is not gonna be sufficient to convey constructive or actual
So you're
notice.
saying that it's not, even that language is not in the chain of title somewhere?
It's not, and even if it is, the language itself is not sufficient
It
to
doesn't
convey
create an
notice.
easement that you're saying, okay.
Yes, it doesn't create an easement, and it also is not sufficient to convey notice,
Okay.
because it's essentially saying that once there is a hike and bike trail here, it's going to be privately owned and maintained by the homeowners association. So that's not enough for somebody who's buying this property years after. I mean, we're talking about 2006 when the plats were, April 2006 when the plats are recorded, and then a month or two late, roughly May 24th of 2006 when the hike and bike trail is completed. So that's not so years later, the appellants purchased this property, and there's not enough notice on, there's not enough, due to this passage of time, there's nothing there to put them on notice that one, that this hike and bike trail even exists, and two, that the homeowners association has some sort of easement or alleged easement or right of access to it. And all there is a note saying, once there's a trail there in the future, it's going to be privately owned and maintained.
Right.
But the person that created this trail, this Ms. DeNovi, never went through the proper procedure to transfer ownership of that.
There's no conveyance.
Right, there's no conveyance. And that's really the issue, is there's no conveyance, and it doesn't fall, it's not under, it doesn't meet the requirements of 1208.02 of the city code, which says there has to be an exact location in the plat, the grantee has to be specified in writing as the city, and the specific use has to be granted to the city. And I believe the note 2 was in the schematic document and not the plat, so I just wanted to clarify that. But there's also language that says that it will be privately owned in the future. So not only is there ownership, not only does the language reference ownership and not an easement, it also specifies in the future. So this is referring to essentially something that hasn't even taken place even at the time that this note 2 was made. So there's definitely not, that combined with the fact that it was never, that this alleged ownership interest was never conveyed, never recorded, never done according to the city code, is not enough to put an owner or a bona fide purchaser such as appellants on notice, either actual or constructive, that this alleged easement is part of this property. Essentially, note 2 is a nullity. It's a promise that it's an unfulfilled promise. And it was not, and the fact that this was never done is not enough to put the appellants on actual or constructive notice, and I hope that answers your question. Just briefly, I want to touch on.
A little more than a minute left in initial time, just so you know.
Thank you, Your Honor. And I also want to point out, the county's trail is the bike and hike trail. The terminology is was a little maybe confusing or a little bit close to each other, but the county's trail is the bike and hike trail. The HOA's alleged trail is the hike and bike trail. And the HOA's was not shown on either of the plat map. The county trail was shown on the plat maps, but not the HOA's trail. And so I wanted to point that out, and the fact that the owners believe that they needed, that others needed permission to access this trail, and I think that also shows that there wasn't a notice that was conveyed here. These are purchasers, these are sophisticated purchasers of this property. This is someone who took the time, researched the documents. This is someone who would be knowledgeable based on the prior ownership of property in Hawaii as to what the laws are governing easements and land use. And he, based on the information that he had received, that he believed, he and the other appellant believed that they needed that others needed their permission to access this property. And if there are no further questions, I reserve the remainder of my time. Thank you.
Good morning. My name is Joe Monroe. I'm here on behalf of the Nottingham Gate HOA and also its individual members. I apologize at the outset for the condition of my voice. I have young children at home. I'm now recovering from my third cold of the season. Unfortunately, I will keep my distance. As you are all aware, this case is about a trail. It's a trail that's used by children, bicyclists, elderly, anyone who wants to access the Summit Metro Park system. We're here today because the appellant, Mr. Dew, wants to block that access.
That's my question. I mean, no matter how you look at notice, how would this now homeowner understand by the deed or by the documents or actual notice that it was open to the public? I mean, even if you went to visit it 5 times and there are people on it, how do you know that it's the public? I mean, the actual document says owned by the homeowners association.
Your Honor, we can't get inside Mr. Dew's head, but based upon what he testified
But
to.
the issue's notice.
Correct. The notice that Ohio law requires in the chain of title, as you've referenced, exists here. It's in a recorded document.
But where does it say it's open to the public in the recorded document?
It says it's to be, it doesn't. It says it's to be accessed and maintained by the HOA, which at the very least
It says it's supposed to be owned by the HOA, right?
and maintained by the HOA. And so at the very least, I would argue the fact that a piece of land, a trail, would be maintained by the HOA would at the very least signal to any prospective buyer that any member of that HOA, any resident in that development, will be able to access that trail.
And let's take a step back on that. Appellant seems to be saying it's on some note to some schematic and not part of the public record. So if I were to go to the plat, is that where this is located? If I look at the plat, they're going to show me a trail going through the property.
Correct. If you
It's going to say so it's going to say it's owned by the homeowner association if I read that, or something to that effect, and we end up with different ownership than what the plat said. But clearly, if I looked at the plat, I would have said the intent of the plat, there'd be some trail.
You would, Your Honor. If you look at the appendix, if you look at both plats which are attached to my appendix, you will see it. If you go to the recorder's website and put in the number, you will see it. It's not in part of a schematic design, it's on the plat itself.
But does an intent to have an ownership interest in the future create an ownership interest in any way?
It may not, and that's not frankly within.
Or easement, or any kind of.
Well, it can convey an easement. It can convey the intent of the parties to have something that's on sublot 15, and that what is on sublot 15 is still being able to be used by and maintained by the HOA. So it's our argument that that is sufficient to create an easement. We are not not here arguing that it conveyed a property interest. We do not claim a property ownership. I shouldn't say interest. We don't claim a property ownership in that trail. We claim an easement to maintain as governed by that recorded plat, as
So
I said.
you're asking us to ignore the word ownership and the word will, and just that the HOA is supposed to will maintain the property?
For purposes of deciding whether or not an easement exists, we don't believe it's necessary for this court to reach the question of whether or not the HOA owns it. The fact that it's to be maintained by the HOA is sufficient to create an easement. That's our position. So there are multiple and undisputed ways, apart from these recorded plats, that established Dr. Dew knew exactly what he was buying. And just to start briefly with the most obvious and common sense manner, he went to the property, he saw it multiple times prior to purchasing it. He testified on those occasions that he saw others on the property, on the trail. And that is not just somewhere on his property, it's on what is clearly evident as a trail. There's a fence, there's landscaping separating the rest of the lot from the trail. It's a gravel trail. The connection of that gravel trail is to another trail, which is located on the sublot to the east of his property, which then connects to the county's walking trail. The fact that there is a fence and gravel makes this unlike a situation where a property owner buys a piece of property, falls in love with it, and then one day finds someone in their backyard who is claiming some sort of interest. That's not the case here. There is something very clear that there's a path and the use of that path by others. I'd also like to point out that the language on the deed, and that language which specifically references the recorded plats, was examined by Dr. Dew prior to his purchase. He went to the county recorder's office, he investigated it. He had the opportunity, if he so desired, to purchase other lots on that property. He still proceeded with the purchase of the subject property, having already investigated and reviewed not only the language, the legal language, but also with his firsthand experience of observing others on that trail. Importantly, Ohio law states that when land is conveyed as part of a recorded plat, the plat becomes part of the description of that property. That's in Kranuski, which is cited in my brief. Ohio law also says that there's no magic language required to create an easement. The encumbrance of this trail on sublot 15 was known to Dr. Dew based upon the recorded legal documents, and it constitutes a legal easement as found by not only the magistrate judge in a reasoned opinion, but also the trial court affirming the magistrate's decision in another independent reasoned opinion. Apart from the physical...
I don't think either the magistrate or the judge analyzed the actual language, though, of that. They said it's recorded, they got into the technicalities, they said it's in the chain of title, but there was no analysis of what that language actually created, right?
Well, I do believe, if my memory serves, that both opinions excerpt the quoted language, and I do believe that there was analysis, certainly by the magistrate judge, as to whether that language meets the qualifications of revised code 5301.01, which governs what is necessary to create a legal easement. So I do believe that there was analysis as to whether that language, which is found in the two recorded plats, was sufficient to create an easement under Ohio law. Apart from the fact that it's in the documents and that it was obvious to anyone who was present, including Dr. Dew, it's been there since 2008. Since that time, the testimony that the trial court, that the magistrate judge heard, was that others, including board members, residents, children, had used that trail. I think it's important to consider for a moment why that trail is there. Hudson made the developer of this property install that trail prior to subdividing it. The question is, why would Hudson do that? Hudson, quoting here, to the maximum extent feasible, requires developers or developments to connect to existing pedestrian or bikeway systems on adjoining properties. That's Hudson Ordinance 1205.04. Why would Hudson want that? It makes Hudson a desirable place to live. It supports home values, which protects Hudson's revenues, but more importantly, there is a safety issue here. Barton Road, which Dr. Dew's property is next to, does not have a sidewalk. And so any member or child on Abbeyshire Road who wants to access the county's trail, if, as Dr. Dew wants, that trail is eliminated, those people will be forced to use the shoulder of Barton Road to access the county's path. That creates a very clear safety concern, and it's another reason why Hudson required the developer in this case to put in that trail, which the developer did, and then noted on the plat that this is going to be the responsibility of the HOA to maintain.
Well, the key is it's noted on the plat. Hudson can want that all they want. If it's not on the plat, it doesn't matter. In this case, you're saying it's on the plat, it's there, he could have seen this when he went to purchase.
That's exactly right, Your Honor. And then lastly, I'd like to bring up briefly the issue of expectations. This is a homeowners association. As you all understand, Ohio law treats homeowners associations and condominium associations differently. There is not an expectation of total liberty that a property owner may have with their property. If your neighbor decides to paint their door bright pink and it doesn't rise to a level of a public nuisance, if you're not in an HOA or COA, your options are limited. In an HOA, there's an expectation and an understanding that you will be subject to certain conditions and restrictions. Now, in this case, other members of the HOA, Ohio law makes, without ambiguity, clear that other purchasers of properties in this development are entitled to rely on the language of that recorded plat, the same recorded plat that Dr. Dew saw. They are entitled to rely on information in that plat that says they have access and that their children have access on this on this trail, gravel trail, to connect to the walking path. That's a selling perk. That's a reason that they may have purchased the property. Its elimination, its potential elimination, not only reduces their home values, it makes them necessary and interested parties in this action. The interests in that path are not limited to the parties in this case, which is Dr. Dew, the homeowners association, and its individual members. It includes every resident, every owner in that development. They are not parties in this case, obviously, and as you saw in my brief, Ohio law, in my opinion, makes it clear that they must be here in order for a valid declaratory judgment to issue.
I have a procedural question. It looks like summary judgment was granted on all claims at some point.
That's correct, Your Honor.
So then the judge just granted relief for one of the claims and had a bench trial instead of a jury trial? I mean, what happened there?
Yes, Your Honor, and I can speak frankly that no one in this room apart from Dr. Dew perhaps was part of this case at that time. But there was a motion for summary judgment on all counts, which was granted. Then Dr. Dew's counsel at the time moved for reconsideration, and the court granted that motion for reconsideration.
So just on one claim though? I mean.
On all, there was not summary judgment granted on any claim. The motion was denied in its entirety, but then to make things more streamlined, proceeded on a trial on only count 5 for the declaratory judgment. I believe based on the understanding that if count 5 was found, was resolved in our favor, the other 4 are meaningless.
Okay.
That's my understanding of why that was done, but I was not counsel at that time. If there are not further questions from the panel, on behalf of the Nottingham Gates Homeowners Association, its board members, and its residents, thank you very much for your time.
Just briefly, that's actually, about using the shoulder, there's actually, if you look at Barlow Road, there's actually a a grass strip in between Barlow Road and the thicket on the other side of the road, so there is room for people to walk on the other side of Barlow Road. And I think that was borne out in the photographs that were in the exhibits. But as far as the note 2, it's on a schematic document, not the plat. Now, even if this court finds that language is part of the plat, the hike and bike trail can't be considered part of the plat because the trail was created after the plat was recorded. The trail was not in existence at the time because the trail wasn't created until May of 2006. The plat had already been recorded in April. So at the time of recording, the trail didn't even exist. An easement by definition is not ownership. And the plain language of this note should control this court's decision. The plain language refers to ownership, not to an easement. It talks about the trail being owned and maintained by the HOA. So even if that had been done, even if all of that were done, it's at some point the note references conveying this ownership the person that created this note was required to convey that ownership interest to the city and never did so. The landscaping around the trail is irrelevant because the HOA's claim relates to the alleged hike and bike trail only. And as far as the notice issue, the appellants investigated, and actually the purchase price of the property was discussed as well. And the purchase price of this property indicates that the appellants didn't have notice of this alleged hike and bike trail or this alleged easement because otherwise it would have impacted the purchase price of the property. I believe it was actually purchased somewhat above market value. So there was some discussion of that at the bench trial, and I did want to mention that. There was a somewhat incomplete or insufficient record on this, but there was testimony in that regard. And I would point out also that even some of the appellee's witnesses, for example, Sugar and Wansick, did not find an alleged easement from the plats, and I believe that was discussed around pages 53 and 55 of the through 55 of the transcript and exhibit 23. So as far as this alleged easement, it's simply not there. The criteria are not met. The language in this note is incompatible with the language of an alleged easement, and any grant that was conveyed through this note could not carry over after the Novi no longer had ownership of the property. So there's no if there's no transfer of ownership of this land or transfer, then essentially there's no property interest that survived at the point that appellants became bona fide purchasers of this property. And I'd be happy to take any further questions with my remaining time.
Seeing none, thank you, Mr. Smith.
Thank you, Your Honor.
And I want to thank both of you for your presentation today on behalf of the court. The court will take the matter under advisement and will issue a decision in due course. When that decision is made, it will be mailed to you by the clerk of courts and also be available on the Ohio Supreme Court website.
Thank you very much.
Thank you.
Hope you feel better.
Thank you.